Welcome back to Canadian Justice, where we're discussing the role of public interest litigants and a recent decision from the Supreme Court of Canada. Mark, in this decision, at the appeal, the government argued to limit public interest standing because of concerns they say should exist over litigating what they call hypotheticals. They said that the government said challenges need to be grounded in real facts. So, how did the court respond to that concern?
Well, I think the court responded by recognizing it is a legitimate concern, but there's a difference between a hypothetical and a situation where a party has pleaded facts that have occurred. And the question is more about how they're going to prove those facts. I want to be clear. The government's position, a concern over hypothetical facts is valid, completely legitimate, and truly hypothetical cases that have no grounding in reality shouldn't be the subject matter of our court's time. What the government was saying wasn't really anything to do with hypothetical facts here. This happened to real people. The only question was, how was the CCD, or how will the CCD prove that those facts did in fact occur? Mm-hmm. That's what's really at stake here.
So one of the things that stands out to me in this case is that this is about organizations' ability to sue the government. And I don't want to be cynical, but certainly it seems like it would be in the government's interest to argue for a really restrictive test that makes it harder for them to be sued, especially if they're being sued by a vulnerable group who is not well positioned to represent themselves as individual plaintiffs. The best positioned people to sue on their behalf might be an organization. If the government makes it really hard for an organization to sue the government, I mean, they're not going to have to pay any damages. They're not going to have to change any of their laws. Am I being a cynic, or is that really what's going on here?
I don't think you're being too cynical at all. There's an element, and in particular in this case, of the government wanting to use standing as a way to avoid meritorious challenges that will be difficult for them to win. They will no doubt have an incentive to avoid cases that they are concerned about losing, or to try to set the circumstances best for winning, or in an ideal world from their perspective to not even have to litigate the case. I mean, the irony here is the government, on the one hand, was challenging the standing of the CCD to bring this case. And at the same time, there's a class action proceeding that relates to similar issues in BC, or the government is fighting the certification of that class action. And they want to have it both ways. They really don't want any cases to proceed against them, it would appear.
I certainly see it as sort of self-serving of the government to argue this way. Now, there have been a lot of cases that have been brought by public interest litigants over the years. Obviously, my organization, the Canadian Constitution Foundation, has successfully litigated some cases. For example, we litigated a challenge to Canada Election Act on a censorship issue successfully as a public interest litigant. What are some other examples of some, really famous cases brought by public interest litigants so that we can see the importance of this type of litigation in Canada's justice system?
The case I'd like to mention, perhaps one of the most famous, is the case called Vriend against Alberta. And Mr. Vriend was a gay individual who had suffered workplace discrimination and had brought a challenge to Alberta's human rights legislation, which did not provide protections based on sexual orientation, being gay or lesbian, etc. Mr. Vriend had a legitimate claim on those provisions in the act that concerned employment matters, but he wanted to challenge the whole act and establish a principle for gay individuals in Alberta generally. And the government fought him on that and challenged his standing. The Supreme Court granted it, and he ultimately succeeded in establishing that constitutional right for sexual orientation as an unenumerated ground.
And did you say in that case the government had also challenged his standing?
Yeah, they challenged his standing to challenge any of the other provisions in the act that didn't specifically relate to employment law matters.
Yeah, I mean, I mentioned earlier that I feel a bit cynical saying the government is using these procedural motions to try and block meritorious claims, but it certainly doesn't seem to be a new phenomenon, at least. We've got to go to commercial break now, but when we come back, I want to talk a little bit more about the decision itself and what CCF, my organization, argued in this case, with you representing us at the court.